Good morning, Mr. Kiley.
Morning, Madam Chief Justice, Justices of the Court. With the aging Garrett Cole, we represent Dr. Flomenbaum. As you know, there are multiple issues briefed in multiple briefs in this case. The first set of questions arises from the governor's motion to dismiss the first 5 claims of Dr. Flomenbaum's complaint. We're here on a motion to dismiss, essentially, and we have referred to those as the contract claims. The second set of items, the back end of our complaint, relate to the governor's motion for judgment on the pleadings as to claims 6 through 12. Those are the certiorari claims. There is an overriding contention that we bring to the court that suggests that these claims are closely interrelated, that they are intertwined. I think the word we used was infused as we were dealing with this case in the single justice session.
Can we agree, Mr. Kiley, or maybe we can't agree, that the record in the case at this level is appropriate to decide these motions in the case? Or are you contending there needs to be a fact-finding procedure at some point?
I believe there needs to be a fact-finding at some point, Justice Graney.
That if the motion to dismiss 1 through 5 is denied.
Yes, and again, the way I think we dealt with this question was with the recognition that if I were going to win the case, I would need to win it at the Superior Court level. But again, for purposes of these first questions on the contract claim, because we are here on what amounts to a motion to dismiss, the facts that are alleged in the complaint are taken as given, and so at some point fact-finding would be required.
Mr. Kiley, I mean, I've read this letter of January 21, and it's got a lot of nice mutual understandings and aspirations in it, but reduced to its essence is the Commonwealth agrees to hire Dr. Flomenbaum, and his tenure will be governed by Chapter 38, Section 2, and Chapter 30, Section 9. And Chapter 30, Section 9 is the termination for cause part. And so if he's been terminated for cause, that's the end of this, isn't it?
I think not, Justice Cordy. The overarching question that I think that exists is whether the government can induce Dr. Flomenbaum and his family to relocate from New York with what we allege is a contractual undertaking, and then act with impunity with respect to the contractual undertaking.
Putting it another way, can one governor induce someone and bind all of the succeeding administrations if the governor makes sufficient enticement?
Justice Ireland, the answer to that is both yes and no. The argument that the government advances does not make the contract void ab initio. The contract is a binding contract, and our principal contention is that if you want to avoid the contract, the consequences of that include contractual damages.
Why isn't the sensible interpretation of the contract simply that it gives, it states a time frame in which the governor expects, sets forth the needs and the accomplishments that the governor hopes will be done, and the 3 to 5 years sets forth the time frame in which the governor expects it to be done. It doesn't overcome the statute.
No, Justice Cowan, and we do not contend that the statute is overcome. Chapter 30, Section 9 exists. Removal for cause exists.
And it has to govern this case. The governor can't contract his ability to remove someone for cause.
No, and we're not contending that he does. In complete answer to Justice Cowan's question, our contention is that the agreement, the letter agreement, the letter of January 21, memorializes an employment agreement that is established with the chief executive of the Commonwealth that that the governor has the right to enter into such agreements. that it is a necessary incident of his power, that the only way that we're going to recruit all of the talents, to use the government's words, is if we can bring people in to handle our problem areas, whether it's the Big Dig or the OCME, and give them some assurance that they're not going to be swept out, that they're not going to be coterminous
You have
with
that
the
in the
governor.
statute. They won't be removed except for cause.
Correct.
And how can a letter overcome that statute?
Again,
They're not
Justice Cohen, I'm not suggesting that the letter overcomes the
doesn't.
statute.
Could I ask you this question? Can you conceive of a way in which your client could lose on the certiorari claim? That is, the court says the governor's proceeding under Chapter 30, Section 9 was adequate in conformity with the statute, even taking into account your argument of infusing the whatever part of that services agreement comes into it. Wouldn't that end your contract claim as well?
I think not. Again.
And how do you get there?
Let's instead of dealing with the abstract, let's deal with the real.
Okay.
And let's deal with the loss of Mr. Brissett's body. Could you determine that the that the misplacement of a body by Lance Anderson, Thomas Mundry, caused by their inattention to the policies and practices that are established for the office, is a cause for removal of Dr. Flomenbaum? Now, I think not with respect to the certiorari claim.
Okay.
But let's assume that you do.
Okay.
I nevertheless contend that the governor, when he agreed to allow this man to come in to address those very problems and give him time to do it, could still bind the Commonwealth to a contractual undertaking. The violation of the contract, while not excusing cause, nevertheless gives rise to a contract claim based upon the agreement with the governor. And
the damages for that would be the
Contract
remaining years of the contract. Is that what you said?
with offsets, with mitigation based upon future employment.
Mr. Kiley, I think I'm beginning to understand. In their reply brief, the governor, in his reply brief, says, in essence, what's happened here is the terms of this contract, if it's a contract, thwart, that's their language, is the purposes of the law. Right?
They certainly make that point, and we disagree.
And you say no, and you say, and as I understand it from your recent statement, 30 Section 9 says that you can be terminated for cause. I think that the governor says terminated for cause. Implicit in that, at least the argument, is at any time, because if there's cause to terminate somebody, you have to be able to terminate them at any time. And you're saying no. A governor can contract to say there may be cause for termination, but I have agreed to let you stay on even if there's cause for termination.
Yes, Madam Chief Justice.
Why is that not inconsistent? I mean, why do we not assume that in 30 Section 9, termination for cause means at any time?
I think it does mean for any time, but again, the question of whether the contract gives rise to a contract claim is different. My certiorari claim, my contention with respect to the standard that you ought to apply under Chapter 30, Section 9, does not depend upon the contract. Now,
let me just go back to that point that the Chief was making. Does the contract that was signed between the doctor and the governor, what you call a contract, does that bind a successor governor?
I think it does. I think that the contract is a contract with the Commonwealth.
Okay. Absent that statutory authority, and we have statutes that allow cities to enter into contracts with people to become superintendents of schools. Chapter 38 doesn't really create that kind of thing. Is there any independent authority in the governor to enter into a contract with someone to come in and serve as a chief pathologist to administer this department?
And I thought I answered the question. I said I think it is an incident of the governor's general authority that he would have the power to contract. And the way we see these claims interacting, and the reason we see them as not undermining the governor's power, is we see the ability to contract as enforcing, as being consistent with the governor's personnel powers. Now, the suggestion, I think, the contrary suggestion turns a person who is appointed in a very unusual way with input from stakeholders from all over the system to a 5-year term. The concept here would be that we're going to turn that person into an employee who is coterminous with the governor, who the governor can remove under the scenario that the government advances for anything that the governor suggests might be cause, without a review of the facts ever.
Mr. Kiley, that piece I understand. Let me go back to your answer, though. It's been a long time since I practiced employment law, but the governor is not unlike lots of other people who want to attract talent to come and work for them. And as I recall it, an absolutely standard contract was, you'll come for 5 years. In other words, you get it out of what in a non-governmental context is an employment at will, but it had a removal for cause. And I don't know of any case where there was removal for cause, and I'm leaving aside whether or not there was cause here. That's a different issue. If there was a removal for cause, I don't think you got your full contract damages. I don't think you got your 5 years.
It's probably been longer that I've practiced employment law than Your Honor.
Unless there's an explicit contractual provision, and maybe this is something that your client I don't know whether or not a contract that provided for that, yes, you can be removed by him for cause. Think of it from the public policy point of view. The governor does not want to have incompetent people. I'm not suggesting he's incompetent, but people who are not doing their job. He can remove him. It seems to me that he might have entered into a contract that said, but if that happens, I'll pay you the additional 3 years, because otherwise the man wouldn't have come.
I hate to duck a question. Again, I don't think that's the argument that has been raised on with respect to the motion to dismiss. But, again, I have looked at the cases not being an employment lawyer, and I have seen them going both ways from the various jurisdictions.
If we were to reach the merits of whether cause existed in this case, you detail in your brief the procedures that Dr. Flomenbaum put in place for checking bodies and the existence of a video that did, in fact, help show the mistake. Now, my question is, when Dr. Flomenbaum was first apprised of the missing body, why didn't he immediately ask to view the video the way the state police did, and then were able to question, and then why didn't he question the people on the video and get to the answer? Isn't that what a good manager would do?
Justice Cowan, that's exactly what occurred in this case. But
I didn't see any statement that he looked at the
But it
video.
wasn't Dr. Flomenbaum reviewing the video, and in my reply brief, my gray brief, I detail the references within the appendix to the examination of the video by Masha Itzi, Mary Kam, Jackie Faherty. That is exactly what was being done.
Those are all employees.
They are the senior staff that were recruited to the office to address this issue.
And was that reported then to the Undersecretary of Public Safety?
Yes, and let me amplify. Mark Flomenbaum learned of the body issue on May 1. On May 1, suggested looking at the video. On May 1, on the evening of May 1.
Well, wait, suggest or order? He's the head. He doesn't suggest.
Suggested is all I can go. The record doesn't say more. On May 1, the staff was undertaking that review under the suggestion made by Dr. Flomenbaum, on May 2nd, the day that they came back to him and told him that it appeared the body was missing, the undersecretary was notified, yes. We are not talking about a long delay. We are talking about a captain of a ship whose staff tells him a problem on May 1, who makes suggestions as how to deal with it on May 1. They're being followed. They result, when followed by the state police, the following day in an outcome that is exactly what we should expect, and the undersecretary was notified on May 2nd.
Could I ask a question? I know your time's
It
up.
might be wrong on, it might be first and second, or second and third, but it's all in the same time.
Mr. Kiley, as I understand the argument about the relationship of the contract to the well, it's actually just to the removal proceeding, is that you would say that the contract, it doesn't heighten or do anything to the standard of what's caused, but it gives a period of time in which Dr. Flomenbaum could act, and so that any effort by the governor to seek to dismiss him for a reason that fit within what the contract dealt with, that didn't give him that time, would be contrary to the contract. Is that?
Yes, and the piece that you added at the end, Justice Botsford, is very important for everybody to understand. We don't think he had immunity or a sinecure for 3 to 5 years. In this particular area, where the parties bargained over particular issues, and this man was coming in to deal with a problem agency, he had that time to deal with those issues.
Okay, here's my question, though. Does that mean, within taking those issues, does he have a free ride? Is that how you'd say it, up until 3 years?
No, again, he has no free ride. Evaluate his conduct at any point in time, his conduct. But if you are going to fault him because the air conditioning in the building is bad, which they do, and he's asked to have it changed, or if you're going to fault him because there are inadequate policies with respect to toe tags, and he's implemented a practice, and he's got training going on, and somebody, the shortstop, boots the ball, if you're going to terminate him for that, if you're going to terminate him because, while there was 1,000 body backlog when he arrived, in the period, the first 3 months of the administration, it took him the 3 months to reduce from 100. It reduced by a magnitude.
What you're really saying, aren't you, is that in every contract there's an implied covenant of fair dealing and good faith.
I have
And in
alleged
this case,
it.
notwithstanding the statute, which says cause, if there's a breach of that covenant, it may allow you to get your contractual damages, subject to mitigation.
And my day in court.
The
Your Honor.
governor is not immune from that covenant in executing or performing a contract that he signs.
And the cases support me in that.
But you're
Your Honor.
also saying that because of that contract, that how you define cause is going to be influenced, and you may not have cause.
I am saying that. I am saying that the contract, the letter of agreement, the memorialization of the employment agreement does infuse, does affect how you're going to evaluate performance, and that's been our contention all along.
Thank you, Mr. Kiley.
Thank you, Madam.
Mr. Barnico?
May it please the court. My name is Thomas Barnico. I'm an assistant attorney general, and I represent the governor and the other defendants in this case.
Can we start with the last point? Maybe you're going to address it a little further down the line, but you would agree, would you not, that the governor, like everybody else who makes a contract, has to perform it in good faith and reasonably?
Yes, Your Honor.
And obviously, doesn't have the right to waive a statute, nor can he, unless the statute permits him, nor can he be stopped in any way.
I also assume, for purposes of the question, that the usual statutes that would govern any contract that the Commonwealth enters will
Yeah.
be satisfied. That issue's been put to the side for purposes of the motion to dismiss because it
Do you
might
happen to know
involve
which,
something.
on the motion to dismiss, which standard we're dealing with? The old one is Nader versus Citron, and as you know, the Supreme Court of the United States has made a major change.
We looked at
Or
that.
does it make any difference?
We looked at that, Your Honor. I don't think it makes any difference in this case because of the nature of our grounds for the
Right.
motion.
Didn't
That
think
is,
it did.
because we argue that
It's a purely legal question.
purely legal, going to the enforceability of this contract simply to the extent that it may conflict with the exercise of the governor's discretion under Section 9. That's the single ground for the 12b6 motion.
Mr. Barnico, if your answer to Justice Glaney was correct, which is that they implied covenants of good faith and fair dealing, and at least there's a claim here that whatever for cause, the language is for cause, but what constitutes a for cause will depend on the circumstances. In what respect do the terms of the letter thwart the purposes of the law, which is the claim that you seem to be making in your reply brief? I mean, I really was trying very hard to think about that. And if I can just explain, maybe with a bad hypothetical, the information technology system in an executive branch is a disaster. The governor wants to have a highly skilled person come to assist fix that problem. The highly skilled person takes one look at it and says, this is a disaster. And I understand there's a for cause termination, but I'm not going to move to Massachusetts and give up opportunities and so on and so forth. If on day 5 I can be terminated for cause because some clash happens that's got nothing to do with my performance, but I would be responsible because I'm the person in charge. And so he negotiates an agreement, and it's laid out pretty clearly, and it says your tenure will be governed by 39 and 38 section 2. And then on day 2 there's a clash, and any normal information technology officer would be held accountable for that, and so in some other circumstance that may constitute cause. And he said, but I can't be terminated for cause. Isn't that what's happened here?
I don't think that's what's happened here, actually, because of the lack of congruence between the very broadly stated general goals of the letter on the one hand and the specific grounds dealing with actions and omissions on the grounds. But I will speak to the
but those are factual questions that somebody might have to determine at some point. But the construct of, there's nothing in the letter agreement that appeared to me to thwart either 38 section 2 or 30 section 9.
Actually, on that point, we argue in the alternative. On the one hand, the only concrete reference relevant to cause in the letter is the cross-reference to Section 9, so we think that for that reason alone it ought to be determined to be the expectation of the parties that cause could be the ground for dismissal or removal in this case. But to Your Honor's question, in addition, I think it's important to look at the claims 1 through 5. I acknowledge, Your Honor, that the letter of agreement of the 25th of January, 05, isn't as clear as a hypothetical that we've been using to show the limits of a governor's power to influence the cause determination later. It does not say, for example, you're not removable for cause at all, or you're not removable according to that subject matter. It's the claims that have been brought forth on this complaint, 1 through 5, that are dismissible because on their face they seek, and as argued by the plaintiff, they seek to constrain that discretion in an unlawful way. It's not the letter.
You're going to have to match those two up, because frankly I'm having a hard time seeing in what way.
Right.
If this letter, if the January 21st, 2005 letter is valid and enforceable, and we have your tenure as chief medical examiner is governed by, so nobody's suggesting that any governor entered into a contract attempting to bypass the legislature. Why would
It's
we not?
It's dismissible, Your Honor, when you look at a claim like wrongful termination, which is one of the 1 through 5
Yeah.
claims, that is dismissible because to the extent that it's claiming a cause of action challenging the removal that's in any way different than the discretion that the governor would have in proceeding under the statutory ground,
But
that's the
if you-
thwarting and that's the
If you read
tension.
into the governor having an obligation to carry out the implied covenants of good faith, this letter doesn't say, and by the way, there's an implicit covenant to proceed in good faith and fair dealing.
No, and my answer to Justice Graney, of course, assumed that if you had an allegation of a contract and all of the other provisions were followed and there was no inconsistency with the statute, and say, for example...
What specifically is inconsistent with the discretion, quote unquote, given to the governor under 39?
It's the claim that areas of subject matter or time period or other factors that would bear on the removal under Section 9, absent the contract, are off limits.
Say that again.
Any of those factors that are mentioned in the letter and alleged to be grounds for a breach, to the extent that those alter the discretion granted to the governor under Section 9.
So you would say, in answer to the Chief Justice's hypothetical, that if this IT person, the governor, brought removal proceedings on day 5 or 10, that he could do that with impunity and that would be fine?
No, he's bound by actions. They can't be arbitrary and capricious. I think that is exactly what arbitrary and capricious would mean, to agree one day that you'll get a year to do this and the next day terminate the person precisely because it wasn't done in a day.
Well, and the
Isn't that how you
reference,
would look
yes,
at that?
to there's no impunity to the extent that the cause determination is always going to be a bar to exercise of arbitrary or capricious action.
But if the argument is that the cause determination has to take into account that there was some agreement that there would be some period of time to effectuate changes. I'm not saying whether it is or isn't, but if the cause determination has to look at that or take that into account, what you seem to be saying is the governor can't bind himself that way.
I don't think he can bind himself in a way that it's a question of materiality, and it is a question of degree. That's why I mentioned hypotheticals like an agreement by one governor to pay a $10 million severance package, or an agreement by a governor to not remove, or an agreement by a governor to remove only for a felony.
We're not talking about that here. We're talking
That's
about
right.
what appear to be perfectly reasonable. Nobody's contested that they're perfectly reasonable. You have a massive problem. You want to attract the best talent. Nobody's saying it's inconsistent. What you seem to be asking us to do is ignore the January 21, 2005 letter. Ignore it.
No, Your Honor. We're asking you, first of all, to notice that it contains the cross-reference to the cause determination.
Absolutely. So there
And
cannot
secondly,
possibly be a claim that the prior governor was acting in some way that was...
no, there can be a claim so long as whatever representation a governor would make in such a letter doesn't conflict with a statutory discretion.
Because it would be ultra vires, wouldn't it?
But you
Yes.
haven't... But what in the letter... What in the letter is ultra vires or inconsistent with the statute?
The letter, it's only as the letter is construed by the plaintiff or referred to in the claims themselves 1 through 5. That's what's inconsistent. That's what's barred by under 12b-6.
But doesn't the letter give him 3 to 5? If you read the letter, it says you have, I take it, from 3 to 5 years to perform certain functions.
Well, I wouldn't agree with that, Your Honor. The letter states some general goals and states a general time period in which it was hoped that
It'd be state-of-the-art. We both believe it'll take 3 to 5 years, in essence, to make this operation state-of-the-art. That's very interesting, but that's not really what we're talking about
and
here.
it's not an immunity,
Mr.
but
Barnacle,
that's where...
let me make it clear. There's no question in my mind that if, for example, and there's no claim of this kind, but if, for example, Dr. Flomenbaum had violated the state ethics laws or had taken a bribe or had no question that this is not, that conduct would A, constitute cause for removal, and B, is not contemplated or governed by the January 21st letter, and even if nothing had been done consistent with the 5 goals and not a dime more and there weren't any more medical officers and so on and so forth, would make no difference. The defense couldn't be, well, I came on the expectation, and when you didn't provide me with the money, I went off and stole my own. Of course, that's ridiculous. What's troublesome here is that what the governor, at least troubling to me, is that what the governor claims is for cause. It cannot be viewed in isolation. It has to be viewed in the context.
Absolutely, Your Honor. And on the certiorari aspect of this case, the governor referred to the complete record, and nothing I've said suggests that the letter of agreement wasn't relevant, admissible, subject to consideration in the totality of the record. It all gets folded in the determination of cause. The principle of law, though, that's posed by the motion to dismiss,
Right.
is the line that's crossed when such an agreement materially alters that range of discretion available to the governor.
Isn't that a fact?
They've alleged more than what I've actually described. They've alleged a substitution of the grounds for termination. That's what their brief is all about.
Why can't we just read the letter as being consistent with the statute, that it refers to the statute, and it's just an understanding? It doesn't alter the for cause standard at all, but it states the time frame in which the governor expects these changes will be made. And then the letter would be consistent with the statute.
Well, the last part, I don't necessarily, the claims would still be dismissible, though, to the extent they assert a contractual obligation that's different than the cause determination you just described.
Yeah, I mean, Judge Cowan is stating your position, I think.
Yes,
This is a
that's
memo
what
of
we're doing.
understanding in substance.
Right.
Yes, in the
subject
first part,
at all times
Yes.
to the statute.
The statute governs, but this letter is just a way of explaining we don't expect you to make these changes in 2 weeks or even in 1 year. 3 to 5 years is a reasonable time frame in which to make the changes that the governor, expect you to make.
I agree completely on the certiorari claims. That's why the cause determination is supported by substantial evidence or not arbitrary or capricious. What I was addressing my qualification, to your point, was that the discussion thus far has focused on whether claims 1 through 5 are dismissible for failure
I
to state a
understand.
claim. And so I was returning the focus of the court to those claims.
I understand, and I'll have to look at. I mean, partly you're labeling under an expanded brief at that, but what I saw too frequently, Mr. Barnacle, from my point of view, was a conclusion. A conclusion. Of course, you can't have a contract that what was the word? Heightens changes the
Or
standard.
constrains the discretion, or constrains the discretion.
But I don't see how, consistent with what's now, I'm labeling the implied covenant of good faith and fair dealing. And what that suggests to me is that there's a factual question. And the question is, who decides that factual question?
Right. Well, again, we disagree that when the court returns to claims 1 through 5, reads them in the context of the entire complaint,
Right.
they will see that they seek to substitute a jury determination, essentially, for the determination by the governor under Section 9, reviewable by certiorari. It's that substitution, that displacement, that altering of the normal statutory grounds that exceeds the mere consideration of the letter of agreement in the totality of the circumstances. It's that substitution you'll see, I think, when you look over, again, claims 1 through 5. That's where the conflict arises. I agree that the conflict doesn't jump off the page when you look at the letter of agreement the way it would in my hypotheticals.
That is for sure.
Right.
That is for sure.
Mr. Barnico, let me focus on one thing. You said substantial evidence. Is that the standard you say we should apply to reviewing the governor's termination decision here?
No, Your Honor. We think
All right, that was a misstatement?
Yeah,
No, that was
just did say
made in
that.
the alternative. I said whether substantial evidence or arbitrary and capricious. It's
So
neither.
your view is what we should be determining is whether the governor's decision was arbitrary and capricious.
That's right, on the certiorari claims. Yeah.
How closely do we, all right, and what do we look at? How closely do we look at the evidence to determine that if we're not looking for substantial?
Well, on that point, Your Honor, arbitrary capricious is defined by the court as lacking any rational explanation that a reasonable person might support. It's generally viewed as more deferential to the government than the substantial evidence.
So we look at, but we do look at the
record.
evidence, yes?
Yes.
Okay.
Do you agree that there was a contract of employment here?
No.
It was a memo of understanding, I think is what your bottom line is.
It's called a letter of agreement, and my bottom line is that it expresses the
But it can't
mutual
trump-
goals and aspirations of the
Right.
then governor.
Can't trump the statute.
That's right, Your Honor.
It can't trump the statute, but why does that necessarily mean it's not a contract? There may be terms of the contract that are inconsistent with the statute, but why does that make it not a contract?
Well, for 12b-6 purposes, it makes it an unenforceable contract. I
Well,
think that the
no, it
thrust-
may be unenforceable in particular ways, but that doesn't make it not a contract. You said it wasn't a contract. I mean, that-
Contract of
I meant
employment. He said of
unenforceable. I
employment.
didn't mean to say anything more than our motion to dismiss says, which is that it's not if it's a contract, it's not enforceable.
Thank you, Mr. Barnico.